Hi, I'm Jamie Ellis with WG Title, and today we are going to review some social media questions that we have come across and go over those people's questions and how to answer them. Okay, so a question that's been brought up on social media, we see it often, people bring this up, but they were facing a situation where the seller didn't show up at the closing and went completely silent. They're asking if anybody else has taken legal action to force the sale. How did it go? How did they navigate? I personally have never had a seller not show up at closing. I've had them try to delay it a few days where they just said, I'm not coming in this day, even though the closing was set. They just didn't go silent. In those situations, I would always say consult an attorney to see what your options are to force the sale. I have heard of people being able to force the sale through legal remedies. I have seen buyers not follow through. I've seen that probably a handful of times over the years. I had one recently over the summer. In those situations, sellers have to look at their loss. Are they going to be able to resell the property? Is it worth their time taking legal action? The one that happened over the summer, it wasn't worth the buyer's time or the seller's time to take legal action. They were able to get the property under contract immediately, close within another 30 days, and they actually sold for more. Sometimes, I would say it's really hard as a buyer when you're prepared and especially if you're going to move into the property and you've spent money on appraisals, inspections, and then adding attorney cost on top of that. But for a seller, sometimes it's better to move on, in my experience from what I've seen, and maybe not take legal action. But honestly, it's going to be up to the parties, how they feel. Sometimes people's emotions get involved and they want to start suing people. But it's not always best to take legal action. Sometimes it's best to walk away. Okay, another question on social media. People, they experience a lot. They said, help, we just bought a house, but previous owners are giving us problems and they don't want to leave. What can we do? Ooh, that is not fun. That's really honestly a sticky situation. If they're refusing to leave, sometimes I have seen people offer them more money to leave. Maybe they're needing a deposit on something. You never know. But if they are just truly refusing to leave, that's when you need to hire an attorney and try to get them evicted or kicked out. In situations where people don't have lease backs, I would always recommend doing a walkthrough the morning of closing. Always do that because you want to be sure, because if, say, they're still fully in the home and there is no lease back, I would refuse to sign and just say they're not gone. I have actually heard this from somebody that they went to go do the walkthrough and it didn't even look like the seller had started packing. There was no lease back in place. It was resolved a couple days later, but it did delay everything. But in a situation like this where they are refusing to leave, you would have to get legal remedies in this situation and to be able to get them out of the home. So in this situation, it's talking about solar panels. Is there any way to get out from under a contract when you believe that somebody's been unethical in what they have sold you, what they've promised? In solar contracts, solar panel contracts, please read the fine print, ask the questions. In this situation, it appears that there was a lady that had dementia that was sold solar panels on her property. In this situation, I would say get an attorney because there could be some kind of elder abuse. If somebody is known to have dementia and they sign a contract, there might be an actual easier way out, but I do recommend getting an attorney that does specialize in elder law in this particular situation because of her age and dementia being an issue. Now, can you normally get out of a solar panel contract? From everything I've heard, it is extremely hard to get out of that contract. If you feel that you've been misled, you lied to, paperwork is not adding up to what you were promised in the signed agreements, I would consult an attorney to see if there are loopholes. Sometimes in contracts, there are ways out, but do request all agreements and paperwork that you've signed. But before you get solar panels, make sure you are reading the fine print and keep copies of everything you sign. And if there's emails where they're promising stuff. Anything, keep it all just for your records, just in case, because you never know when you may need it. Let's read about this deal that somebody posted to social media. It was regarding a subject to. So this is somebody saying that they bought a home, ended up being more than they could handle, put it on the market. They could not sell it the way it is with interest rates being what it is. And so they had an investor come to them regarding a subject to deal where the mortgage would stay in place. The investor would take over payments. Since that, they ended up going through with the deal. And since it's happened, the person that was received it via vesting deed from the seller, they've destroyed their credit. What can we do? So as a title company, not all underwriters will insure subject to closings. There are some. As a title company, we have everybody sign off on a ton of paperwork, letting them know that it is risky. I know people are sold on it from investors. It's great for investors because this is a way they can get a mortgage without really having to do anything, say 3%. It's extremely scary for sellers because you do have to expect them to make those payments. And because it's still in your credit report, it doesn't leave your credit report. It's not always a good situation for a seller. It's great for the end buyer, the buyer that's assuming that mortgage, because they're not on the hook. If they don't pay it, then it doesn't affect their credit, but it will affect yours. And it will affect yours, say 5 years down the road, you get your finances in order and you want to buy another home. Guess what? You can't, because that other mortgage is still outstanding and in your name against your credit report. Us here, we have everybody sign off. We inform sellers it is risky for you. Are you aware of what you're doing? We have you sign off, and us explaining that over and over again. We also have everybody sign off on the same stuff, all that documents, way prior to closing. So we need all of that reviewed and in the file so everybody has a time of at least 7 business days to reflect. What are they doing? Is this really what they want to do? Is this the best decision for them? If you're a seller and somebody's approached you with that, it's not always the best for you. There may be other things better for you to do. So you may not have funds for an attorney, especially if you're trying to do subject to because your home can't be sold. But if you can, I would always pay for a consultation with an attorney, but also read all the paperwork the title company gives you, because as a title company, we insure it to the buyer, but we're also taking subject to that existing lien. So that's not part of their title insurance policy. But read the fine print. If you have questions during the process, please ask the title company. Come up with questions. Anything you think of, ask us, because we'll be able to at least explain it to you so you can make a better educated decision for your particular situation and for your future. So another social media post, it is a investor that was purchasing a wholesale deal, and the wholesaler wanted to hold the deposit. So on most of assignment of contracts, the wholesaler will collect a deposit that can be dispersed, and it's usually non-refundable. And they were asking if people are seeing if these wholesalers are wanting the title company to hold the deposit or the wholesaler. What do I see as a title company when we receive these assignment of contracts? I would say 50-50. So as a title company, it's great if the wholesaler holds it, because if people start fighting over money or deposits, we're not stuck in the middle because the funds aren't held in our escrow account. But I would say about 50% of the time, the wholesalers will want to hold it personally. And the reason being is because end buyers sometimes just disappear on you. They've assigned the contract to it and they just don't show up, which means that initial person on that contract is responsible to fulfill that contract that is executed with the seller. But in half the time, we see wholesalers holding deposits. Some of the larger wholesaling companies, won't name names, but they normally will hold any of those deposit funds, which is okay by us. We are okay either way. But just understand, if people start fighting over money, that kind of puts us in a third-party situation where it needs to be resolved between everybody before we can release funds. But it is wholesalers trying to protect themselves from people just walking away and not closing as agreed per the assignment of contract. Remember, if you guys have any questions or comments, our contact information is below. Leave a comment, reach out to us, let us know how we can help.